DeWaal here, and this is Bridging the Week for November 3rd to 7th, and today is November 10th, 2014. Good morning! The 30th Annual Futures Industry Association Futures and Options Expo may have occupied the main stage in Chicago last week, but continued preparation for the rollout of new futures industry rules, including, principally, important measures involving the protection of customer funds, as well as new proposed tweaks to previously adopted old rules, occupied the day-to-day plate of many remaining back at the office. As a result, futures industry themes dominated the financial industry landscape last week, but large banks were also told they could not get significantly larger, and one Fed governor proposed the implementation of standardized stress tests to help ensure the critical reliability of clearinghouses. There was a lot going on last week, so let's get started. At a public hearing on November 3rd, the Commodity Futures Trading Commission proposed 3 measures intended to avoid unintended consequences arising from previously adopted rules. These proposals were to eliminate the current automatic acceleration as of December 21st, 2018, from 6 p.m. to 9 a.m. each day by when Futures Commission merchants must use their own funds, so-called residual interest, to cover the aggregate margin deficiencies of their customers in certain customer-protected account environments. Instead, each charge would only occur after a formal rulemaking process. Eliminate a rule provision that on its face requires commodity trading advisors to record oral communications regarding their futures and swap transactions, and to clarify that oral and written communications leading to the execution of transactions do not need to be maintained in a form that permits identification of particular transactions, although they must be searchable, and clarify that certain non-speculative forward contracts that provide for variations in delivery amounts, so-called volumetric optionality, are excluded from the definition of swaps. In recommending the issuance of the proposal to delay the automatic change in time FCMs are required to contribute residual interest, Commissioner Mark Weichin seemed to acknowledge the challenging economic situation many FCMs currently face. According to Mr. Weichin, quote, "Clearly, while the Commission must weigh the cost to FCMs of its risk management requirements, it need not scope them to ensure that every FCM that exists today has systems and practices in place to comply with them. Going forward, the Commission should strive to ensure adequate accessibility to the marketplace, knowing its importance to market liquidity, but remain vigilant in enforcing current FCM requirements under its rules." End of quote. Commissioner J.Christopher argued that not only should the automatic change in time provision related to residual interest be cancelled as proposed, but other automatic provisions in CFTC rules too, such as the automatic lowering of all the de minimis threshold to become a swap dealer from $8 billion US dollars to $3 billion in 2016. In advance of new customer funds protection measures effective November 14, the Joint Audit Committee issued 2 regulatory alerts that provide helpful guidance regarding FCM's new requirements to maintain amount of their own funds, residual interest again, in certain customer origin accounts by 6 p.m. Eastern Time each business day, at least equal to the sum of customer margin deficiencies incurred as a result of activity the prior business day, and take an undermargined capital charge for any customer, non-customer, or omnibus account that fails to meet a margin call by close of business on T+2, where T is the day an account first becomes undermargined. And the JAC also clarified that an FCM may continue legally to accept orders that don't solely reduce the risk of existing positions while an account is undermargined or in debit a reasonable time. A reasonable time is less than 5 business days for customer accounts and 4 business days for non-customer and omnibus accounts. An FCM, however, may impose stricter requirements. Both Chairman Timothy Massad of the Commodity Futures Trading Commission and Sharon Bowen, Commissioner, set forth their priorities before audiences attending the Futures Industry Association's event in Chicago last week. Among other matters, Mr. Massad indicated that staff currently is working on capital and position limit rules, but provided no insight into a possible time frame, except to say, in connection with the position limit rule, quote, "We're going to take our time to get it right," end of quote. Mr. Massad also addressed a number of cross-border issues. He indicated he supported an extension of the end-of-year deadline for staff's no-action relief that pertained to when a foreign swap dealer conducting certain activities in the U.S. was subject to U.S. transaction requirements. He also noted that the CFTC continued to talk to European regulators regarding their recognition of U.S. clearinghouses. Finally, Mr. Massad discussed the importance of protecting against cyber attacks and the measures the Commission is taking to help ensure a quote-unquote system safeguard. However, he noted the CFTC's inability to engage in independent testing and lamented that, quote, some of our major financial institutions are spending more on cybersecurity each year than our agency's entire budget, end of quote. Ms. Bowen noted that her presentation was her inaugural speech. Among her priorities, she identified finalizing the CFTC rules regarding position limits and addressing the quote-unquote changing role of technology in the markets. Jerome Powell, a governor of the Federal Reserve System, called last week for consideration of, quote, some sort of standardized approach, end of quote, to stress testing of clearinghouses, to better assess their individual risk profiles as well as to better understand overall, quote-unquote, system resiliency. Although Mr. Powell acknowledged that there was some truth to the concern that the move to central clearing may, quote, further concentrate risk in the financial system, end of quote, he said this is not the intent. The intent is to reduce risk through netting of positions, greater transparency, better and more uniform risk management practices, and more comprehensive regulation. Mr. Powell argued that, quote, understanding the effect of correlated stresses on a wide array of clearinghouses is important for ensuring overall system resiliency, end of quote. Mr. Powell gave his remarks last week in a presentation at the 17th Annual International Banking Conference in Chicago. In his speech, Mr. Powell also said that clearinghouses must ensure they maintain adequate liquidity and are transparent with their clearing members regarding stress test results, margin models, and default fund size. And finally, the Board of Governors of the Federal Reserve System adopted a rule to prohibit certain financial companies, mostly insured depository institutions, from merging, acquiring, or otherwise consolidating with another company if the surviving entity is too big. Under this new rule, too big would occur if the surviving company's liabilities immediately after the deal exceeded 10% of the aggregate liabilities of all financial companies. This new rule is effective January 1st, 2015, and implements a requirement under the Dodd-Frank, Wall Street Reform, and Consumer Protection Act. Well, that's it for this week's Bridging the Week. As always, there's more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week, and ciao!